Good day, I am John Margaret Torres and our group was assigned to discuss Chapter 4, Reformation of Instrument. Article 1359. When there having been a meeting of minds of the parties to a contract, their true intention is not expressed in the instrument purporting to embody the agreement. By reason of mistake, fraud, inequitable conduct, or accident, one of the party may ask for the reformation of the instrument to the end that such true intention may be expressed. If mistake, fraud, inequitable conduct, or accident was prevented the meeting of minds of the parties, the proper remedy is not reformation of the instrument, but annulment of the contract. Obviously, the first paragraph of this article talks about reformation of a contract, and the second paragraph talks about annulment. But what is reformation? As stated, reformation is a remedy in equity, whereby a written instrument is made to conform to the real intention of the parties, where some error or mistake has been committed. It is not automatic to have a reformation if your contract is in contrast to your real agreement. In order that an action for reformation of instrument may prosper, the following requisites must observe. First, there must have been a meeting of minds of the parties to the contract. Then, the instrument does not express the true intention of the parties. Finally, the failure of the instrument to express the true intention of the parties is due to mistake, fraud, inequitable conduct, or accident. Let's take an example. Johnny's car is worth 1.5 million pesos, but Johnny and Bogart agreed for a selling price of 1 million pesos. However, in the written instrument provides 1.5 million pesos. The remedy is reformation kasi nagkaroon naman sila ng meeting of minds na 1 million pesos, but the written instrument that they executed does not reflect the true intention of the parties. Another example. Johnny is selling his car to Bogart for 1.5 million pesos. But Bogart thought that he is buying Johnny's car for 500k pesos or 500,000. They executed deed of sale and in the written instrument stated that the car fixed price is 1.5 million pesos. The remedy is annulment because there is no meeting of minds at all. Always remember the requisites in order to execute proper remedy. Article 1360. The principles of the general law on reformation of instrument are hereby adopted insofar as they are not in conflict with the provision of this code. This article simply says that in case of conflict between the provision of the new civil code and the principle of the general law on reformation, the former prevail or the new civil code pa rin ang susundin. The general law on reformation will have only suppletory effect.
Good day everyone, I'm Jean Patricia Cruz and I will report about Article 1361, Article 1362, and Article 1363.
Article 1361.
1361, when mutual mistake of the parties causes the failure of the instrument to disclose the real agreement, the said instrument may be reformed. Note that in reformation of contract, what is reformed is not the contract itself, but the instrument embodying the contract. In Article 1361, applies to instrument that is embodying a contract wherein both parties committed mutual mistake o ang parehong partido ay may nagawang pagkakamali na nakaapekto sa tunay na nilalaman ng kontrata. For example, A and B orally entered into a contract of sale of a house and lot which was located on Lot 4, Hyacinth Street, South Green Heights Village, Putatan, Muntinlupa City. But by mistake, the contract as written and signed by the both parties stated that the house and lot sold is located at Lot 14, Hyacinth Street, South Green Heights Village, Putatan, Muntinlupa City. We can see that the first address stated is different from the second address which was written in the contract. Therefore, the contract of sale may be reformed on the ground of mutual mistake that was caused by the both parties. The requisites are A. The mistake is a mistake of fact o ang pagkakamali ay dapat na isang pagkakamali ng katotohanan. Letter B. The proof of the mistake must be clear and convincing. And for the last one, letter C, the mistake should be common to the both contracting parties. Subsequently, reform will not be granted unless there is a clear and strong proof of each other's wrongdoing.
Article 1362.
The next article is Article 1362. If one party was mistaken and the other act fraudulently or inequitably in such a way that the instrument does not show their true intention, then the former may ask for the reformation of the instrument. Take note that the mistake referred in this article is for unilateral. When we say unilateral, only the offerer has an obligation, compared to bilateral, wherein there is a reciprocal obligation from the both parties. Again, this is for unilateral. This article implies that the written instrument may be reformed where the mistake is unilateral and the other act fraudulently or inequitably. Ano nga ba ang ibig sabihin ng fraudulently at inequitably? Ang ibig sabihin nito ay mayroong pandarayan na involved o hindi patas na ginawa ang isang partido. For example, A agreed with B that the former would loan 500,000 with the latter. In the contract signed by A and B, it was stated that A was selling his house to B for the said amount. A signed the contract in a belief that it was really a contract of loan. In this case, A can ask for the reformation of the instrument because one is mistaken and the other act fraudulently.
Article 1363.
The last article that I will report for today is Article 1363. When one party was mistaken and the other knew or believed that the instrument did not state their real agreement, but concealed the fact that the former, the instrument may be reformed. On this article, if the party is guilty of concealment and attended with bad faith, therefore reformation is authorized to avoid injustice and equity while the second party is not aware of the imperfection. If they acted in good faith as the first party, therefore the mistake becomes mutual and reformation is authorized. For example, unilateral A owed 5 million to B and made a promissory note that she will pay B her land title in Cavite, which is equivalent to the amount that she owed. 6 months after their contract was made, A delivered her land title to B as her payment for her debt to the latter. B accepted the land title, but she noticed that it was the land title of A in Ilocos Norte, not in Cavite, which is 3 times more than the amount that A owed, but she concealed it to A. Therefore, A is entitled for the reformation of the instrument that is used for their contract.
Article 1364. When through the ignorance, lack of skill, negligence, or bad faith on the part of the person drafting the instrument or of clerk or typist, the instrument does not express the true intention of the parties, the courts may order that the instrument be reformed. Ignorance, lack of skill, negligence, or bad faith must be part of a third person. Under the Article 1364, neither the party is responsible for mistake, hence either party may ask for reformation. Article 1365. If the two parties agree upon the mortgage or pledge of real or personal property, but the instrument states that the property is sold absolutely or with the right of repurchase, reformation of instrument is proper. Mortgage or pledge states as sale. Any of the circumstances enumerated in the law exist. An instrument purporting to be a sale with the right of repurchase shall be presumed to be an equitable mortgage. The true intention of the parties must be prevailed. Article 1366. There shall be no reformation to the following cases. Number 1. Simple donations inter vivos wherein no condition is imposed. Donations are essentially pure liberality. Number 2, wills. A will may be revoked at any time. Number 3, when the real agreement is void. A void agreement, in essence, is an agreement that did not exist at the very beginning. Hence, there is nothing to be reformed.
Good day, I am Janice de Castro, and I will be reporting Article 1367, 1368, and 1369. Article 1367. When one of the parties has brought an action to enforce the instrument, he cannot subsequently ask for its reformation. O sa Tagalog, Artikulo 1367, kapag ang isa sa mga partido ay nagsampa ng aksyon upang maipatupad ang instrumento, hindi siya makahihiling ng malalim na pagbabago. 1367 is based on SFL Article 1431 or ratification. When the party brings an action to enforce the contract, he admits its validity and that it expresses the true intention of the parties. The bringing of the action is thus inconsistent with reformation. There is no prohibition against joining in one action the reformation of instrument and its enforcement as reform. Example, Anna sold Ben a car. Anna fraudulently made the contract one of chattel mortgage instead of sale. Both signed the contract of chattel mortgage, with Ben believing all the time that it was a contract of sale. Ben, therefore, has the right to bring an action for the reformation of the instrument. But if Ben brings an action to foreclose the mortgage, he is by said action enforcing the instrument. We cannot therefore subsequently ask for reformation of instrument to make it one of sale. Article 1368. Reformation may be ordered at the instance of the either party or his successor in interest, if the mistake was mutual. Otherwise, upon petition of the injured party or his heirs and assigns. Tagalog, ang pagbabago ay maaaring ipasunod ng alinman sa partido ng kanyang tagapagmana. Kung may parehong pagkakamali, kung hindi man, sa petisyon ng partido o kanyang tagapagmana at mga takda. Example, Brad and Lee entered into a contract whereby Brad sold to Lee his Mercedes-Benz. By mistake, the written contract and the sign by the party states that the sold Mercedes-Benz is Tesla. Supposing that the contract was made by a third person through ignorance, etc., under Article 1364, neither party is responsible for mistake. Hence, either party may ask for reformation. Article 1369. The procedure of the reformation of instrument shall be governed by rules of court to be promulgated by the Supreme Court. However, the Supreme Court has not yet promulgated the procedure for the reformation of instrument. Under Section 7, Rule 130, Rules of Court provides evidence admissible when the original document is a public record, when the original of the document is in the custody of a public officer or is recorded in a public office, its contents may be proved by a certified copy issued by the public officer in custody. Therefore,
That's all. Thank you.